Where do people count? By Rob Kerr. First, patch poster, August 12, 2012. Niles resident Rob Kerr first weighs in on the recent decision by Niles village clerk not to certify the term limit challenge. The question will not be an option for voters on the November ballot. The following letter to the editor expresses the opinions of the author, and patch serves as a platform to allow readers to state their views. I love improvisational comedy as much as the next guy, but not when it abrogates the rights and frustrates the intentions of Niles citizens. On Tuesday, August 9th, Niles village clerk Marlene Victorini announced that she will not certify the Niles term limit initiative to appear on the November 2012 ballot. Apparently this decision was made unilaterally by Victorini since the signatures of the other two members of the Niles Election Commission, Mayor Calero, and Trustee Preston, were not affixed to the letter of notification. This suggests that the commission never met to consider this matter, and that Victorini acted alone after receiving legal advice from a firm hired by the trustees. In her letter of notification, she cited two technical violations that she deemed to be severe enough to invalidate all the signatures on the petitions. Both objections are laughable and neither is a violation of state law on local initiatives. First, Victorini objects that the petitions state an incorrect standard for determining the number of signatures required. There is nothing in Illinois law that mandates that the target number of signatures be listed on the petition, correctly or incorrectly. The standard Niles organizers needed to meet is 8% of total votes in the village cast in the last gubernatorial election. They met and exceeded that number. They also met the lower standard of 10% of the voters in the last mayoral election, which was mentioned in the introductory paragraph of the petition. Similarly, her second objection references rules in state statutes that quite simply are just not there. Here Victorini lists three transgressions. The petitions you submitted failed to a. State that the person circulating the petitions was 18 years of age or older, b. Certify that the signatures on the sheet were signed in the circulator's presence, and c. Certify that the signatures are genuine. The notarized statement at the bottom of each of Mr. McCullough's petitions reads as follows: I am and have been a registered voter of Niles, Illinois, residing at the address below. At all times I have circulated this petition. I certify to the best of my knowledge and belief that the above signatures at the time of signing this petition were registered voters of Niles, Illinois, and their addresses were correctly stated therein. Where's the problem? State law does not require the circulator to identify himself or herself as 18 years or older on petition forms. It simply requires that any person signing petitions for submission be of legal age. The statute reads as follows: at the bottom of each sheet of such petition shall be added a circulator's statement, signed by a person 18 years of age or older who is a citizen of the United States. Besides, any reasonable person who sees Mr. McCullough self-identify as a registered Niles voter on the form, as required by the state statute, knows that all voters in Niles are age 18 or over. If anyone is at fault here, it is Victorini who failed to check McCullough's ID, apparently. The clerk's rejection letter also charges that Mr. McCullough is submitting signatures that are not identified as genuine in the circulator's statement. How ludicrous can you get? Why would anyone submit petitions that are not genuine? And who would admit that they aren't? These frivolous charges strain common sense and are based on a very curious, and largely incorrect, reading of Illinois election law. Of course, nobody ever accused the legal profession of an excess of common sense, but it is quite clear that none of these objections rise to a standard sufficient to invalidate the Niles term limit initiative, especially since the top-notch legal team advising Victorini created two new requirements that are not in state law: 1. The specification of one's age on the petition, and 2. The listing of the signature target on the petition, neither of which is required by Illinois statutes. Undoubtedly the state circuit court will reverse this decision upon appeal. But after all, that's the whole point of the clerk's decision anyway, to force the organizers and supporters of the term limit initiative to waste time and money responding to these frivolous objections to the initiative as important deadlines for appearing on the November ballot draw near. Regrettably, In Niles, any opinion that challenges the established power structure does not count for much of anything, even when more than 1,000 voices speak in unison. In this case it apparently didn't even merit the full attention of the duly constituted election commission charged with the legal responsibility of reviewing such matters. The citizens of Niles deserve more respect than this. I urge the Niles Election Commission to reconsider this specious attempt to kill the initiative. And I call on Village Attorney and Nunzio to assist these citizens in their appeal. The village has just clarified that Mr. Annunzio serves the citizens of Niles, not its government. Now is the time to match words with action and offer his assistance to those citizens. Rob Kerr, First, Ph.D.